Welcome to Ballantine Law, clear, practical legal advice that works. Hello, I'm James Ballantine and I'm the Managing Director of Ballantine Law, and today I'm joined by Steph Burns, who's a solicitor who works in our commercial and estates team.
So James, today we're talking about granny flood agreements,
Yep.
and I had a few questions I was hoping you
Sure.
might be able to answer for us. So we've seen an increased number of people asking about granny flood agreements. So what are they?
So a granny flood agreement is where a person, and that's typically an elderly parent, but not always, makes a contribution to another person, which again typically is an adult child or an adult child and their partner. And in return for that contribution, they receive an interest in that person's property or a right to reside in their property for the rest of their life. That interest is known as a granny flat interest, and the agreement is the agreement between the parties in relation to it. I think we're seeing a surge in inquiry about this area for a number of reasons. Mainly, older people often own their own home, and that home has increased in substantial value over the years. When, for some reason, and it's often because of the death of a partner or ill health or otherwise, that property is no longer viable for them to live in, they need to sell the property, and then they have a significant amount of cash in their name, and that can have a real impact on their social security means tested entitlements. So what granny flat arrangements can do is allow people to enter into an agreement, often with their family members and sometimes with other people, to allow them to continue to live closely with family, have a level of care and support without necessarily having to immediately go into some sort of expensive retirement living.
Yeah, exactly. It gives them a way to stay at home and spend time with their families.
Yes.
So do these agreements, they need to be in writing, or could they just be orally, discussion between families?
They don't have to be in writing, but because the primary use for these, or the primary motivation for these, is often social security, having something in writing is an effective way of demonstrating to Centrelink that there is a granny flat agreement in place. Probably even more important, having something in writing allows both parties to be very clear about what their expectations and obligations that they're giving under the agreement is.
Exactly. So what does a person receiving a granny flat interest usually contribute, and what do they get in return?
It's usually one of two things, either a lump sum cash payment or a property that they own themselves, where they'll give the entire property to the other party. So we see generally one of those two.
Yeah, and what are they usually getting in return for that?
Well, they're receiving a right to reside or a life interest in the property, so they can live at another property for the rest of their life, and that's usually in the property with the child or the other person who they're in the arrangement with.
Yeah. So a granny flat makes people think of a standalone sort of detached property in a backyard. Is that always the case?
No, it's probably more rare than you think. Despite the name, a granny flat interest can cover any kind of interest in a property to reside, an exclusive or non-exclusive right. It's often in someone's house or unit or otherwise,
so like without
necessarily having to build a typical granny flat.
So what type of things do you think a granny flat agreement in writing should usually cover?
Well, there's probably a few things that a well-drafted granny flat agreement needs to address. Firstly, the formal requirements for under the social security legislation as to what constitutes a granny flat interest, what's being paid and what sort of interest the person is receiving. Often these agreements will be covering some kind of care or support that the child is providing for the parent. That can include things like shopping support or even medical or general care support. You'd want to address the typical outgoings associated with living, so things like electricity, water, internet, cable television, who's paying for those things. It's really important to address what happens at the end of these agreements, or what happens if for some reason the agreement needs to come to an end. So what happens if there's a breakdown in the relationship between the parties, or if there's even a breakdown in the relationship between the couple that are granting the agreement, because the property can itself be subject to family law proceedings. What happens if the property is no longer viable, or the person's no longer able to live in the property because of their own ill health or advanced age? What happens if a dispute breaks out, how that's dealt with, how the interest is valued if the agreement comes to an end, or whether a substitute arrangement can be made. And then there's other areas, depending on the nature of the arrangement, that can be considered.
Yeah, great. So what are the social security implications of having a granny flat interest?
This is where it starts to get complex. There's a lot of complex rules around how granny flat interests are valued and how the disposal of a property or cash to another person affects someone's means testing. So we always recommend that people obtain financial planning advice or advice from Centrelink experts on the area, so they can have a real understanding of how these matters can affect their entitlements.
What do you think the biggest mistake that families usually make with these arrangements?
I think not getting the right advice and not getting it early enough. Rushing into it making the contribution or granting the right into the property without anything formally in writing and not understanding what the implications really are. So seeing someone early is generally better than seeing someone after the problems arise.
Yeah. In these circumstances, do we think that both sides should usually have their own lawyer?
Absolutely. Even though everyone might be on the same page and have the same objectives at the end of the agreement, both parties have different interests and there are different protections that need to be put in place, and it's just not possible for a single lawyer to act for both parties in this type of transaction. So when we talk to clients about them, we always recommend the other party get their own independent legal advice.
So if someone's listening to this and they're thinking, well, that sounds like our family, what do you think they should do next?
They should speak to a lawyer who's familiar with these types of arrangements. The legal costs associated with putting these kind of arrangements in place pales into comparison with the costs, both financial and otherwise, when things go wrong. So seeing someone as soon as possible, getting that advice, putting a plan in place before money even changes hands is probably the best advice we can give people.
For more legal insights, subscribe or visit ballantinelaw.com. We're here to help.